Good evening. This is Rahul Reddy. We are here live from Houston, Texas. Every Tuesday from 5 p.m. Central Time to 6 p.m. Central Time, we bring in immigration updates. Emily, what do we have today to discuss?
Today, we're going to talk about the consequences of duplicate H-1B filings. What happens if you get a notice of intent to revoke or a notice of intent to deny? The big news on Friday was the announcement that 780,000 registrations were received in the H-1B lottery, and of those, 408,000 were duplicates. So only 350,000 genuine applicants. What is USCIS going to do with all of these duplicates? So we'll talk about that. And then because of that, what are the prospects of a possible second lottery this year, which we did not have last year? And we'll talk about PERM delays that are continuing. What are some strategies you can use for your H-1B if it is nearing the 6-year limit? And we're working with a lot of clients these days that are working on 2 different jobs. They generally have their H-1B, and then they've also got their 485 pending, so they have an EAD, and they're choosing to use the EAD to work for those 2 jobs. So we'll talk about that. What are the things to be aware of, and which one is the right way to go if you're in that situation?
Emily, we have posted a video separately on this topic of duplicate filings. What are the consequences of it for the employers? What are the consequences of it for the employees? Of course, we have got a lot of intent to revokes. We also have misrepresentations. That means that they have a lifetime ban for the employees to ever come back into the United States from the consulate. Yet, I see when I looked into the comments of it, they are telling that duplicate filing is legal. You can do it. Can you tell it's legal or not? Why it's not legal, or in some instances why it's legal?
Yeah, there are definitely different shades of duplicate filings. We're not talking about the situation where someone has an offer from Facebook and an offer from Google, and both of them submit registrations. That is not a duplicate filing. I think those are legitimate jobs. What we're referring to as duplicate filings are when you're working for one company and that company submits the registration, and either the person or the company shares this information with other companies for the purpose of increasing your chances in the lottery, and those other companies also submit registrations for the same person. Those other companies probably never interviewed you. They have no idea what your background is. They have no job for you at this moment, yet they are submitting this registration and signing it electronically under penalty of perjury, saying that they have a valid job offer for you and they've never even talked to you before. Those are what we're talking about as duplicates. That is fraud. That's definitely, those companies are just popping up out of nowhere. They've never filed before, or maybe they filed in the last few years. They're filing hundreds of registrations. I mean, this 408,000 registrations came from just 96,000 people. So 96,000 people submitted at least 4 to 5 registrations per person, and they were all filed with the same groups of companies and things. So that's where the issue is. And no, that is not legal to do. It's definitely meant to game the system, and USCIS is seeing this, and now they're going after these companies criminally at this point.
Emily, there are a couple of statements which I've seen people contradicting us. One of the things is that these 2 companies, or these 10 companies that filed for me, are not related companies, though. Do you still see a problem there?
Yeah, I do see a problem there, because I'm questioning whether all 10 of those companies actually had a job offer, a legitimate job offer for this person at the time they submitted that. And the whole purpose of them submitting with 10 different companies is to game the system. And that's pretty clear with the number of registrations that are being submitted.
Emily, isn't the job offer supposed to be from October 1st, not right now? Why are you still saying the job offer has to be there in April or May?
Yeah, I mean, that's the USCIS requirement. When a company submits the registration, they're specifically saying there are these little check boxes that they have to click on before they hit submit, confirming that they have a job offer. Now, of course, that offer is for a start date of October 1st. So it doesn't necessarily mean they're employing this person today. But it's very questionable when the person has a job, is already in the US and working for one company, and that company submits the registration, yet all these other companies are submitting a registration as well. And we know those companies don't have valid job offers. They're either saying they're going to put you on an in-house project that doesn't exist, or they're going to find a project for you later. Even when they file the H-1B, they say they're going to work in-house. And then 2 months later, they start marketing the person to find them a client. Then they put them on that client site, and then they fail to file an amendment. We see it every day, these companies doing this. And the employees come to us begging, please help me. I've got a notice of intent to revoke because of all these things that the company did. Well, you know.
Wait, Emily. I have to contradict you. You get the intent to revoke. Do you actually get to see the intent to revoke when the employee contacts you? Or
a lot of times, no. Yeah. So nowadays, we've gotten so many messages just in the last week from people saying, my employer got a notice of intent to revoke, but they won't share it with me. And they're telling me to file a transfer.
With the employee?
Of course, because there's something in there that the company must have done wrong, or that's what USCIS is alleging, and maybe the employer has no way to overcome that, and they're just not willing to come clean with the employee, and that puts the employee in a difficult spot. They're just telling the employees, hey, you need to go transfer somewhere else, but just transferring somewhere else does not make the problem go away when that initial H-1B cap case ultimately gets revoked with the finding of fraud. Because then they're going to say that this employee, because of the fraud, has not actually been counted in the cap. And then they're going to go after the next company saying that you need to go file in the cap. Therefore, we're going to deny your extension or deny your amendment. So it's going to keep following these employees, and it follows them to the consulate. People are now getting 221Gs with a finding of misrepresentation, which is a permanent bar. So this is something to be very careful about. I mean, what are you recommending people that did submit with multiple companies and got selected? Should they go ahead and file at this point?
They should not file. The reason is that these people may get a permanent bar forever entering into United States. They're only looking for the temporary gain. Even that doesn't look to be, that looks to be a mirage to me right now at this point of time. They should not file the application. If they have filed the application, they should withdraw the application before it's been even approved, though. And if they have filed an application, if they've just even filed an application, though, even if it's selected or not selected, they should consult a lawyer, because it may be collaborating with the employers to defraud the immigration, to get the benefits from the immigration. So I would strongly recommend these people to contact a lawyer if they have filed the duplicate filings of the H-1Bs. Now, Emily, when these people are contacting of the notice of intent to revoke, you admitted that these employees don't give the notice of intent to revoke. Obviously, there are some cases where the employers contacted us and they did give us the notice of intent to revoke. Can you disclose the content? Of course, as a confidentiality, we're not going to disclose the names of the company. What is that you see in those notice of intent to revoke?
Yeah, we're seeing two different types. One is specifically regarding the multiple filings. So USCIS will provide a list of employees that this company has registered for, and then they will provide a list of all the other companies that happen to register for those same exact employees. Clearly, how is it that two companies can register for the exact same set of employees? That should be a red flag right there. You know, it's one thing if one person gets registered with two different companies, but the same group of 50 people being registered with the exact same group of companies, and it's not just one company.
Owners are different here, is what their employers come to us for consultation, yeah.
Yeah. So, and then the USCIS is seeing that they look at the public records of these companies. They see that they've used the same registered agent in their articles of incorporation filing with the Secretary of State. They see sometimes that they're sharing an office space. They see that they're using the same FedEx account. They see that they have the same signatories, the same people signing documents, the same people signing the checks. They look at all of these different things and cross-reference them. And it's when you've got that many things that are shared with the same group of people, it's very easy to see that companies are clearly working together and know of each other and have shared names to register multiple times. So that's the most common thing that we're seeing right now. And then some of the other notice of intent to revoke that we see are for companies that, like last year, did these duplicate filings, really didn't have a job offer, filed the H-1B petition, just putting the company's company's office as the work location. And then the employee never goes to work at that work location. They find a client for them instead and move them to the client, and then file an amendment 6 months later when you're supposed to file an amendment before you start work at that new location. A site visit happens at the original location and there's no one to be found. It's a PO box, sometimes post office box, virtual office. So those are also leading to notice of intent to revoke, because they can see that that petition was not really valid at the time of filing. There was no actual job.
So if I'm an employee, if I get a notice of intent to revoke, what can you do for me, Emily?
Well, obviously, if we don't have a copy of it, we're kind of stuck because we don't know what we're fighting against. The other issue, as the employee, you're technically not a party to the H-1B petition. It's between the petitioner, the company, and USCIS. The employee plays no role in that process. And so if the employee were to try to submit a response to that notice of intent to revoke, USCIS doesn't have to look at it because you're not a party to that application. So there's not really anything you can do right now. You can, other than transfer to a different company temporarily. But once that petition gets revoked, then maybe the employee, if there is a finding of fraud, you can do a Freedom of Information Act request to get a copy of the revocation, a copy of the notice of intent to revoke, a copy of what was submitted in response, and then possibly file a lawsuit with USCIS if you can claim that you, as the beneficiary, played no role in this. Then you have maybe some possibility of at least getting it reopened and revoked without a finding of fraud on the part of the employee so that you can keep your cap number. But that's a very long road to go. And you've got to be careful of any travel, any visa stamping going during all of this process, because any of it can lead to a finding of misrepresentation as well.
Emily, I'm getting a couple of questions on this topic before we move into the other topic. We're going to cover this more broader. One guy is telling that, Ganesh is telling, he knows a person who filed 25 applications and got selected 18 times. He wants to report about the consultancies abusing the law. Can he do that? If so, where? There is the provision. In fact, when you look into the USCIS press release, there is a link there that is provided. You can go to rnlawgroup.com. There is an email address. We provide fraud report. That searching it in RN Law Group, fraud report to USCIS. And then there is an email address that you can send the report. When you send the report, give the exact details. Give the details of the employee also. Pretty much this guy is already screwed up because he got into 25 applications, but still, you still need to, I would still strongly recommend that you report it though, so that these kind of people, these kind of criminals will never ever be able to survive in this society though. And not only that, we need to come out clean as a society. Indian diaspora, we need to make sure that we don't have these kind of criminals among us, and if there are, then we need to give up to the authorities, and so that they can spend time in the jail. That's a very nice place for them to spend their time. Mohan Bolin is asking the question: if employee gets genuine job offer from 2 to 3 employers, and do you still recommend not to file the H-1B application? One, Mohan, we doubt whether you or whoever this person is got the 2 to 3 employment opportunities at the same time. it needs to be evaluated independently by a lawyer. Yeah, if it is Facebook, if it is Coca-Cola, if it is Pepsi, I do understand that. But consulting companies with the PO boxes filing an H-1B, definitely not. We don't see that. There is a genuine job opportunity when you are not working for the company. And most probably you're not working for 3 companies at the same time. So that's another indication where it's a fraud. So what looks like a duck, walks like a duck, talks like a duck, most probably is a duck. So we need to evaluate it and see if it's not a duck, it's a dog. That needs to be evaluated. Just a statement like you that it is not fraud doesn't make it. It doesn't relieve you though. Emily, is there, when people consult me and they say, I didn't know that it was fraud to file with multiple companies. Can they still be in trouble because they didn't know?
Yeah, I definitely think they can, especially when they have no role to play in the revocation process. USCIS won't really accept any documents or information from the employee. So regardless of whether the employee knew or not, the company certainly committed fraud, and that leads to a finding that the cap number is not there. There's, if the employee really didn't know, maybe there's options to litigate it in the future and get it reopened and revoked without the finding of fraud on the employee's part. But I really question when people say they didn't know, because these job offers most of the time just seem too good to be true. It's a company you've never heard of. You got a reference from a friend. You never had to give them your resume. They never interviewed you. All they asked for was a copy of your passport. Who hires someone like that? I would never hire someone without talking to them first and seeing their education documents, looking at their resume, having an interview, and letting you, the potential candidate, ask me questions about the job so that you feel confident knowing exactly what it is you're going to do if you join my firm. So if you've never even talked to this employer about the actual job, never been interviewed, never been questioned what your qualifications are, maybe you didn't know, but probably you should have known at that point.
I want to differentiate, guys. If you are not aware that your company has been sending your resume to the other, sending your name and details to the other, there may be a relief. But if you know that they are filing it and you don't know it's illegal, is irrelevant. Even if you don't know that it's illegal, knowing the law is a duty. It is not an excuse. You can't say, oh, I didn't know that, I can't murder somebody. No, that's not an excuse in law. So if you don't know the law, it's not an excuse, but only if you didn't know that your company is actually passing the information to other companies and passing, there may be an excuse for you. But if you know that they are filing duplicate applications, you still give your passport information, you did not restrict them filing the H-1B, you may be doomed at this point of time. Let's move on to the next topic, Emily. Now, with especially the comment of this gentleman that this guy got 18 selections, and of course he's not going to file 18 H-1Bs though. Do you see a second lottery coming in?
Yeah, I mean, that's right there, 17 slots that were taken up that aren't going to be filed. And think of if there's 96,000 registrants that accounted for 400,000 of these multiple duplicates. Surely we're going to have a lot of the 110,000 selections not actually be filed. Hopefully people that did have multiple registrations will listen to this and not file at all. But even the ones that do file, they're only going to be filing one out of the several that they had selected. So we should see a second lottery, I would expect. I think with USCIS announcing that they are looking at criminal action for these people, hopefully that's finally scared people enough to not file when they're in this situation, which will hopefully open it up to some of the legitimate applicants.
Emily, right now, PERM labor certification is taking a long time. And if my 6 years is expiring, what are the alternatives that I have to stay in United States or probably eventually get back to H-1B without going through the lottery system?
Yeah, so, knowing that the PERM process is taking much longer than usual, number one, start the process early. So if you are in the first 3 years of your H-1B, go ahead and have that process started now so that you don't end up in this situation later. But if you already are at a point where you're into your 6th year and your PERM has not even been filed yet, you need a way to recapture time. So that's one option, is to exit the US, stay outside the US for some time, come back before your current H-1B expires, and then file an extension to recapture that time that you've spent outside the US. And you can keep doing that until you get to the point where you either have the PERM and I-140 approved, or your labor certification has now been pending for 365 days. So that would be one option. If you have the ability to switch to an H-4, maybe your spouse has their own H-1B, then you can change status to H-4 while you wait for your PERM and I-140 to be approved, and then file a change of status back to H-1B. At that point, you don't have to go through the lottery because you've already been counted and you're taking advantage of AC-21 to extend beyond the 6-year limit based on an approved I-140. So those are going to be your best options, but most importantly, start planning those things now, early. Don't wait until 1 month before your 6-year limit is reached and then say, what do I do? Because there are ways that you can take some strategic vacations or work remotely from your home country for some time to be able to recapture.
If you are coming near to 6 years, guys, there are many different ways, as Emily has pointed out. But B2 is one of the options you can consider. H4 definitely going outside the country. But more important is that it's better to consult a lawyer. But I don't like people consulting me at 5 years and 11 months and 28 days and call me and pay the money and say, find a solution. I mean, that's very hard for me to do it. But if you would contact at least 3 to 4 months before, then there are some creative solutions. The best would be to actually contact a lawyer before 2 years. That's the best solution. But if you can't, at least 3 to 4 months is a better way of contacting. Emily, if I have a AOS EAD and I have an H-1B and I filed AOS with, let's say, Coca-Cola Company, and I have a H-1B with Coca-Cola Company. Now I want to work with, on the side, AT&T on an EAD. Can I do that? Can I do 2 jobs without the AT&T filing an H-1B, concurrently filed H-1B? That means that with Coca-Cola, I'm working, they have H-1B and AOS EAD. With AT&T, I just have an EAD. Can I do that?
Yeah, you can do that. In that case, the job with AT&T, your side job, whatever that job is not really relevant because you're still with Coca-Cola, for example, and they are still sponsoring the green card. You're still planning to work for them when you get your green card. So this is just a side job, and you can use your EAD to work on that side job without impacting your pending I-485 application. But be aware, your H-1B only authorizes you to work for the company that holds the H-1B. So once you start working for a second company that does not have a concurrent H-1B, you're using your EAD, you're technically no longer in H-1B status with Coca-Cola. Now you're in adjustment of status, which is lawful stay, but you're using your EAD to work technically for both companies, even though Coca-Cola is unaware that you're doing that. In their eyes, you're still on H-1B. They only need to look at what is your current work authorization when it's time to renew. At that point, you can provide them with the EAD card instead of having them extend the H-1B. But once you use that EAD, you're technically not in H-1B status going forward.
Am I obligated to inform the Coca-Cola company that I'm working with a different company, EAD?
I don't think, unless you've got an employment contract that requires you, that tells you that you're not allowed to moonlight or something like that, I don't see any requirement. There's no immigration requirement for you to notify them. That company's job is to make sure that you are authorized to work through one way or another. They did that at the time they did the I-9 based on your H-1B. And then when it's time to do your next I-9, when your H-1B is expiring, then you can choose whether you want to get back to H-1B status or use the EAD. Have you seen issues with people with their 485 when they go to the interview, for example? Do officers understand that people can work two jobs?
Sometimes they don't understand, Emily. Some people understand it. These are government employees that barely work 8 hours. They don't understand how people can work for 16 hours. I always recommend people to take a lawyer with them if there is an interview, so that it can be explained that they can work for multiple jobs on EAD and they can work for 16 hours. There's nothing wrong with it. They're not working for the government, so that's a very good source where they're allowed to work for multiple companies. So it's always good to do it. But have I seen any denials of the 485 because they work for multiple companies? Zero, none, never. Let's go to questions, Emily, unless you have something else to discuss.
Nope, we can go to questions.
Brahma Reddy is saying that in the last 30 years, they are working without jobs. They're able to file the H-1B. Will they start revoking from past 30 years? We're not aware of that. Without jobs, you can file H-1B. I'm not aware of it, Mr. Brahma Reddy. So I don't know which world you live in, which world you live in. But yes, have I seen the H-1Bs getting revoked without job filing? Plenty of them. In fact, I get more consultations when the H-1B gets revoked because it's been filed fraudulently when there is no job at all. That happens. I mean, not that I'm telling that there is a fraud there, but it's not to the extent what you're saying, everybody files without a job. No, not everybody files without a job. There are some people that file without a job and they do get revoked. Typically, USCIS used to take 3 years to revoke those kind of things. Nowadays, they're taking about 1 year. They become much efficient right now.
Rachid wants to know, can I use my I-485 EAD card to renew my driver's license at the DMV without impacting my H-1B status? Yes, you can. No issues with that at all. So you're not using the EAD card to work. You're using it for other purposes, which is totally fine. It will have no impact on your H-1B status.
One good question that comes out is that how do I know that my company got the notice of intent to revoke? Well, there are 2 ways for you to know. One, multiple ways, but main 2 ways are that you check your status online with USCIS. It will tell you that there's no notice of intent to revoke that was sent. The best thing that I tell everybody is to create a My USCIS account, put on all the receipt notices in there. So if there is any update, you will get that information. Instead of every week, every 2-3 days, you go checking it, the best is to create My USCIS account. Anything comes in, it will come as an email, and they even allow you, if you allow, they even will text you that there is an update that you need to have it. That's the best way of knowing whether there is any intent of revoke for your H-1B. And be noteful, guys. Let's say company A filed the H-1B in the lottery. You got the H-1B approval. You moved on to company B, and maybe you moved on to company C, and maybe you moved on to company D. Always watch for the first H-1B if it's been revoked. Now, there are multiple ways. If it's revoked because of the withdrawal of the H-1B, that's not going to cause any problem. If it's revoked for fraud, that's going to create a problem for you.
Hemchen says, my PERM has been denied because of an incorrect address used in the notice of filing. Can you suggest on the chances of getting it approved if a motion for reconsideration is filed? So I'm assuming the incorrect address is the DOL address because they moved from the Atlanta processing center to DC. And they did inform people in advance that the address needs to be correct on the notice of filing, and there was a certain cutoff date. So any notice of filing posted after that date had to have the new address on it. It is a very strict rule. I do not see any chance of success in a motion to reconsider. So the process should be started over immediately. Maybe try filing the motion or appeal if you need to have that PERM pending to be able to extend your H-1 for just 1 year. In the meantime, have the new prevailing wage done, start the recruitment all over again, make sure the notice of filing is correct this time around, and refile.
Is it possible to switch from TN to E2 in country? If yes, can I go to Canada after that? Yes, you can switch from TN to E2. You can go to Canada after that, absolutely, not a problem, and come back. One question that comes from Parth Trivedi is, if someone H-1B petition is revoked due to denial in fraud case, can they still convert into H-4? Right now, there are some instances where the employees were being hit with misrepresentation, saying that the employees were part of the misrepresentation or fraudulent activity. If that happens, they are doomed. You can't get the H-4. You have to file it's called Haranka waiver, that takes a year, and that too you'll have to go outside the country. But once it's been revoked, though, assuming that the employee is not involved in any of the fraudulent activity, the best solution for them is for them to go to India, get the stamping, and come back rather than trying to convert here. Because to convert here, they will look into the status. Did you maintain the status? Since the H-1 by itself is a fraud, they may say you didn't maintain the status. So the best solution is just go outside the country and get the stamping done. That would be the best mode.
Cigar says, my priority date is September 2013 with a pending 485, and my EAD and AP are approved. And he wants to know if he can take a promotion to a managerial position with his employer that comes with a raise and new job duties. So USCIS has come out with some guidance for AC-21, which is the law that allows people to port their green card to a new job offer without impacting your ability to get the green card, as long as the new job offer is the same or similar to the one that you were originally sponsored for. They've specifically said that they recognize career progression and the typical type of promotion that you may receive over time with these long pending applications. They do recognize that for AC-21, so they often do recognize that that is considered to be a similar enough job to qualify for AC-21. I've never had an issue with submitting a supplement J for someone who's taken a promotion to a manager level position where they're now managing the type of job that they were in before and that they were sponsored for. So generally, that's not an issue.
A question that comes from a person who's in Canada. What do I need to do to get into, if there is a second lottery, what is that I need to do to participate? Assuming that you already participated in the first lottery, you don't have to do anything. You're automatically will be in the second lottery if they do conduct it. You don't have to take any positive action on it. A question from Vasanthi Navuluru Louis. The question is that after getting I-140 approval, can I change the employer before the 6 months? Does it cause any issue during green card? The main issue is that, is this your first I-140 approval? Assuming that this is the first I-140 approval, though, it is strongly advisable that you stick with the company for at least 180 days after it's been approved. The reason is that if they withdraw the I-140, though, there will be a negative consequences. You cannot use that I-140 to extend the H-1B beyond 6 years. You cannot use that I-140 to apply for your spouse H-4 EAD. So these are the negative consequences. So I strongly recommend that you stick with the company until the 180 days are over. Now, it won't have a negative consequences in the long run for the green card, but remember the two negative consequences that I spoke with you are good enough for you. It should discourage you to move out of the company within 180 days.
Raj says, what is the average time it's taking to process the PERM? So assuming that you're at the very beginning stages, have not submitted a prevailing wage yet, you need to plan on a good 18 to 24 months to get through the whole PERM process, all of the prevailing wage, the recruitment, the filing, to get to the point of a PERM approval. They are taking close to 9 months once the PERM is filed nowadays.
Sindhu Reddy has this question. Do you see any closed dowry cases in India that led to any problems in the H-1B extension or I-485 denials? With regards to the dowry case, when it comes to the H-1B extensions within the United States, never a problem. Now, when you're speaking about going and getting the stamping in India, that may be an issue. With regards to the 485, that may be an issue. I normally recommend if you are, served, or if your opponent has filed in a dowry case, it's a felony case. So you should contact an immigration lawyer, especially the immigration lawyer that have a law degree in the United States and India. Probably will be of a greater help, like me, better than Emily in this case. In a dowry case, I strongly recommend to go with the lawyers who have law degree in India and here. That would be much better because the way it's handled in India is quite different.
Talk to San asks how to expedite an AP renewal. I'd like to use the EAD, but I'm not using it because of the AP renewal processing time. And if I travel out of the US while the renewal is pending and my current AP is expired, I can't come back. That is correct. You've got two options to expedite. Number one is to follow the USCIS expedite procedure, look at what their criteria are. If you can show you have some urgent need to travel outside the US, then you call the 1-800 number, you make your case to the officer, and then they'll decide whether in their discretion the case deserves being expedited. It's very rare that they do actually expedite them because the processing times are pretty terrible, so everyone's requesting the expedite. And even if they do expedite it, it still takes a couple of months to get the AP approval. So your other option is litigation, which we are doing in our office for these interim benefits, and it does help with that processing time. Stephen Brown is in our office handling those if you want to reach out to him regarding those details.
Roshan Pasi has this question. How strict is USCIS with day one CPT pending AOS marriage-based? We have never seen any denials of the marriage-based if it's a day one CPT. We have never seen it though. Unless, these are the universities like Farmington, University of Northern New Jersey, Silicon Valley, or Tri-Valley University. These are the four things. Definitely there may be some issues, but otherwise, other than those four universities, we have never seen any issue of the 485 denials. Question that comes from the gentleman is very confusing though. Prasad Boleni, my AOS EAD renewal applications got rejected due to not sufficient application fees? Really? That doesn't look right to me. Did you send the filing fees? If you do send the filing fees, that definitely seems to be a problem. There is no filing fees for AOS EAD renewals in the employment-based category. There is none. So definitely that's a confusion. The officer has it. It should be notified properly to the USCIS saying that there's no filing fees required. Maybe when you file the next time, print it out from the USCIS website, highlight the dummy guy, tell them, look, dummy. No, don't use that word, guys, okay? Look, dummy, the filing fees is not required. I'm filing under the C09 section. You do not need filing fees, and send it back. Put a color sheet in there telling that.
Pavan says, I'm on my green card EAD. Can I change the location with my same job in the same company without having to go through the PERM process again? So as long as your I-140 is approved and your 485 has been pending for at least 180 days, yes. AC-21 allows you to change jobs. It allows you to change jobs within the same employer or even same employer, different work location. You don't have to go through the PERM process again. You take the green card process with you to the new location. And if you get an RFE, you can submit a supplement J showing that the new work location is there and that will not have any issues for your 485.
Pratyusha got a green card recently, congrats, and she went to India, she came back. She doesn't see the I-94 and her passport is not stamped with the entry. Is that going to cause a problem? First of all, there is no I-94 for you anymore. You got the green card, you don't need I-94, buddy. No, just because they didn't stamp in the passport, it won't cause any problem. But make sure that you keep the tickets, the online reservation tickets that you travel from, let's say, Lufthansa Airlines or whatever airlines, just keep it because you may need it at the time when you go for the N400 citizenship. You don't need it. Sometimes if they question you, have you ever traveled, you just mention that you do, but if they just ask any proofs, you can always provide them. Look, I went in Lufthansa, came back in Lufthansa, here's evidence for that.
Sudhir says, may I know what is an NOIR and an NOID and what are the consequences of it? So I'll start with the NOID. So that is when you have filed an application, USCIS, and this goes for any type of application, not just H-1B, not just I-129, but any type of application. And USCIS has not made a decision on it yet, but there's something in the application that makes it look like you don't qualify for it at all. Instead of sending a request for evidence, they instead send a notice of intent to deny, saying, look, we don't think you qualify for this. We plan on denying it, but hey, if you've got documentation or an explanation that overcomes why we intend to deny it, we can still approve it. So with an NOID, they only give 30 days to respond versus a request for evidence where you usually get 12 weeks to respond. So the processing time, you've got to be very quick with that. So NOID means they have not denied it yet, but they plan on denying it unless you can prove that you qualify. NOIR means they've already gone through the application, they've already approved it, and now new information has come to light and they think that that approval was incorrect. So they now plan on going back and revoking that approval. Now they can also revoke it because the company withdrew the approval of either an I-140 or an I-129, and that's not a problem. But we're talking about when the approval, the original approval, was done in error because it was not a legitimate job offer, because the company was operating out of a PO box location, or because the company did multiple filings, multiple registrations in collusion with other companies. Those are the reasons why USCIS might intend to revoke something that's already been approved. And the consequences of that, if they actually do revoke it, if there's a finding of fraud with that revocation, it means that your H-1B cap number is no longer valid and you have to go through the lottery again. And there may be a finding of fraud on you as well that can make you inadmissible, cause you to get a 221G if you go for stamping, or put you out of status in the US.
A lot of people have questions with regards to the filings. What is legal, what is not legal, though? In general, in flat, we would say that if 2 filings is illegal, if you think so otherwise, consult a lawyer to make sure. As Emily pointed out, if it's Facebook and Apple both filing, yes, that may be legal. We're not telling that everything is legal, but in general, though, we qualify. And now everybody says that my company's Apple and my company is Facebook. Well, I don't know how the 700,000 applications have been filed by Apple and Facebook. So it doesn't look like they did not file those things. So, and a lot of people will say, I have 2 genuine job opportunity for consulting companies. I take it as a big no, because we doubt these intentions of these companies. Now, having people reporting to me that for the L2 visa holders, filed multiple H-1B applications, got picked up. How is it effective? We strongly recommend do not file the H-1B. And if the H-1B is filed, withdraw it before it's approved. Now, at this point of time, we're not reporting any USCIS or CBP or State Department taking actions if you never filed the H-1B, never got the H-1B approval from the company. We have never seen them yet, though. Would they do it at a later time because you colluded with these employers in filing the H-1B? They can, they may. But at this point of time, we have never seen any action on the employees when the H-1B is not approved. But could they do it at a later time? Yes. Is there any preventive measure what we can do? No, it's already done. We do not have any time capsule in Reddy Neumann PC so that we can send you back and then you can correct yourself. Our office doesn't have it. So we can only advise you going forward what is the best solution, though. Going back and correcting, there is nothing we can do about it.
Anik says, do you need the physical copy of the H-1B approval to start working for the new employer in a transfer situation, or is the notice of online approval enough to start work? Actually, you don't need either, because when a transfer is filed, you don't have to wait for the approval before you start working. You can start working based on the filing of the transfer. Now, the company will need to use some specific documents to show that you're authorized to work based on the filed transfer. That's typically going to be your I-94 with the old company and your passport, and then a copy of the I-129 petition that they filed and the tracking information to show when it was delivered. Some companies prefer to wait for the actual receipt notice before they'll start the process, but if it's already been approved, then they could utilize the I-94 plus the passport plus the proof that they filed that transfer in order to allow you to start working.
Deepak has this question. Birth certificate doesn't have surnames and mother changed her name. Should I submit affidavits for both parents showing current name details? Yes, definitely both parents signing an affidavit is good. But at the same time, you can provide additional documents. The additional documents includes Aadhaar card, PAN card, ration card, election card. You can include all those things. Normally, I only submit affidavits, though. I would not submit all the other Aadhaar card, PAN card, ration card, election card, birth certificate from the hospital. I do not submit those things. But if there is an RFE, I would submit. So I would tell the client to keep it ready for me at a later date if there is an RFE. With regards to your mother's name change, though, when they're writing in affidavits, always write. Let's say, for example, her name is Lakshmi, and her previous name was, for example, Saraswati. So I would say that Lakshmi, previously known as Saraswati, that's what I would include in the affidavit. Now, when the name change in India requires that, the name change should be published in a gazette. It is a government thing that is published. So when the name, you should get the gazette and keep it with you to provide it to the USCIS if there is an RFE. Why is your mom's name Saraswati in the birth certificate, but you are telling it's Lakshmi? Then you explain to them, look, here is the gazette. My mom changed my name from Saraswati to Lakshmi. Here is a gazette. That they will take it and they will accept that one.
Prasad wants to know, can I travel to India with a valid AP while my AP renewal application is pending? So if your prior AP has not yet expired and you'll be coming back before it expires, you can travel. And it should not impact the pending renewal. But if it has already expired, then you cannot travel.
Devendra Bukia has this question. H4 submitted multiple applications, not selected in any of them. Is there any risk for applying for EAD? Right now, we don't see, but we don't know in future if that's going to be true, whether they're going to reverse it, because they now identified this 96,000 people who have applied in multiple applications. The last time we have seen this kind of thing, Emily, was when they published the people who are on OPT and STEM extension. They published it and they said that it is these companies that are using the OPT and STEM extensions more, and they've given the company's name. And the company's names, you know, what do you expect the top companies? Amazon, Apple, Facebook, and all those things. Surprisingly, there are two companies that we never heard of. One thing is called Integra, one thing is called Aztec. They published, and we were very shocked at the time, where are these companies coming in? Then when we found out that Integra and Aztec are using the same address. So if you combine both those companies, though, they are bigger than any of the Fortune 500 companies to use the OPT and STEM extension. Then the USCIS and the ICE went and hit with a misrepresentation for almost 6,000 of those 10,000 people, though. Could they do it at this point of time? We don't know. Have they done any misrepresentation for these people without being H-1B applied or getting the approval and going to the consulate? No, we have not seen it. Could they do it? They can do it. Should they do it is a different question, but they may do it at a later time, but right now, you cannot go back and change in time. And that's the reason we always tell that please listen to our Tuesday live session every week until you get the green card. Emily, did you warn the people before not to do, or is it just because USCIS came up with this, you are coming with this story right now?
Yeah, I think every year before April, we come out with a video warning people don't do this. No one listens, apparently.
It's not no one, it's 400,000 applicants or 96,000. Now, Emily, here is one other thing. The theory is that it's the 96,000 people they have identified to have filed for the duplicate application. Could there be more people who have not been identified? Because some of these people have learned some techniques. So if your name is Emily Neumann, and Neumann can be spelled a little bit differently, because when it comes to German spelling, it's different spelling. When it comes to the US spelling, it's a different, or Czech spelling, it's a different. When it comes to US spelling, it's different. So these people have used the different spellings in their names and filed it. They have learned some stupid techniques, not so good techniques. They should not have done that. They should not have filed it, but there may be some people who may have done that too, though. So at least they have identified the 96,000. They have not identified the rest of the people. Just wanting to inform how these people do the tricks. I get these consultations. Oh no, I don't have to worry about it, Rahul. My last name, I misspelled it in there and filed this application. I don't know if the USCIS caught them or not caught them. I don't know.
Krishna says, what are the alternate options for PERM experience letters from previous employers if I can't get them from one employer? So first of all, you technically don't need the experience letter to file the PERM because the PERM is an online filing. You don't submit any documents. You do need the experience letter for the I-140 stage. So number one, make sure that you actually need that experience letter because you don't always have to have an experience letter from every single company you've worked for in the past. You just need experience letters from those companies that meet the experience requirement listed for your position. So if your position only requires 2 years of experience and you've worked with 5 different companies, but you got your 2 years of experience from one company, you don't need the other 4 companies' experience letters. So make sure you actually need it for one. But then if the company is no longer in existence or there's some reason why they can't provide an experience letter, you can get affidavits from former coworkers that confirm what your job title was, what your salary, not your salary, your actual job duties and the dates that you worked there and how they're aware of this information. And then you can support it with secondary evidence, which would usually be your offer letter that you do have from the company and pay statements or W-2s that you've gotten while working for that company. So yes, there are alternates for that. And if you go to immigrationgirl.com, should be a blog post about that experience letters, options if your employer won't provide them.
Question that comes in here is, how do you know the 485 interview has been waived? Is there any way to know? Only one way. When you get the green card without an interview, that means that they waived it. There is no other way.
I've seen a FOIA request where in the notes that the officer
on the
put
first page on the left side of the I-485 application, they say interview waived. Emily, but can they still interview afterwards?
Oh yeah, for sure.
So that's the reason where, after the FOIA, I see that interview is waived, but I've seen still people getting interviewed. So that's the reason I say if it's a guaranteed way to know if your interview is waived, is the only time is when you get the green card without interview.
Pratyusha says, we recently came back from India on GC, but the officer did not stamp the arrival on our passport.
I already covered that.
Oh, you got that one? Yeah, so I want to mention that they had a pilot program where in certain airports they are no longer stamping the passport. And they've expanded that nationwide. So going forward, most people will not get any stamp or any notation in their passport. And the only option is to look online, but that wouldn't apply for green card holders.
Dave Paul asked this question. My I-140 is approved for 2 years, and then I left the employer. my old employer revoked my I-140 as a company policy. I hope it's not going to affect the priority date. You told me that you left the company after 2 years, and after 2 years, I-140 is going to approve. Then they withdrew the I-140 application. You absolutely will not have any problem whatsoever at all for putting the priority date. You will have no problem using that I-140 approval to get the 7th year extension, not just with the same company that you're working, company B, company C, company D, company F. You will have no problem in using that I-140, which has been withdrawn, to file for the H-4 EAD for your spouse. You will have no problem, because the general rule you need to remember is that it's been withdrawn after 180 days it's been approved. So that's the key point for you, what is doing much better for you.
Abhijit says, can I apply for the EAD AP renewal 1 year before it expires, or does it only have to be 6 months before the expiration? We have been doing it and have not seen any issues with filing that far in advance, because the AP processing times are 1 year right now. So technically, I think they want you to wait till 4 months before, 120 days before they expire, but we've not been paying attention to that and just filing and not seen any problems.
Girish has this interesting question, Emily, I want to discuss with you. I guess that will be enough time for us. We won't have enough time to cover, but it's an interesting discussion. He said, what's the benefit USCIS has been realizing every year by allowing unconditional, unlimited H-1B registrations? One thing I would comment, Girish, is that you are right. I mean, absolutely, there is no doubt you're right. They should have curtailed this in the early stages of the filing the H-1B, not right now. But right now, it has come to a stage where H-1B by itself, the lottery system, is unsustainable with the amount of fraud that has been committed. If you look into the USCIS, the amount of duplicate applications, it's going up. But right now, it's more than the genuine applications that will be filed. In fact, it is more than 100% of what the genuine applications have been filed. So it has come to a stage where either you stop the entire lottery system or you better correct the fraudulent application. That's a message USCIS is getting from a lot of congressmen and senators. So they definitely will correct it, is my expectation, Girish, because if they don't, next year what's going to happen? All these fraudster guys will get a boost. Then we will see a registrations of 10 million registrations. Who knows? God knows. And out of them, most of them are duplicate. So definitely, they have realized it. In Hindi, we have it. Der hua hai, magar durast hua hai. So that's a word that I can say. I don't know if English rhymes to that, but yeah, they will take an action because it's too much for anybody to handle it.
SEMA has filed the 485J due to a job change, and then after 6 months got a request for evidence for the medical exam, even though the priority date is not current, and wants to know, what does that medical RFE indicate? Well, it certainly indicates USCIS is, again, being inefficient, because why are they asking for these medical exams for people who don't have a priority date that's current or near becoming current? And we're seeing that quite a bit. So I think that it doesn't indicate anything other than USCIS is just wasting time getting medical exams for people that might expire yet again.
Anything else, Emily, before we conclude?
I think we're out of time for today. So thanks again for joining us. And don't forget that we do have a free daily conference call where you can also join. Go to rnlawgroup.com to get the details for that, and also join our newsletter subscription so you can get the latest updates every Wednesday when we send out that email blast.
Thank you very much.